I've already highlighted the key factors which you need to keep in mind as far as an arbitration agreement is concerned. The other factors which also need to be borne in mind when clients sit with their lawyers or their counsel to draft an arbitration agreement is the rules which would govern the arbitration. Now, parties have a choice either to opt for an ad hoc arbitration or institutionalized arbitration. Now, what is ad hoc arbitration and what is the guide which the parties should follow? Not a, I wouldn't say guide in a stricter form, but a certain indicator. If the dispute does not involve a huge sum of money and big companies or it's between individuals, then they can opt for an ad hoc arbitration. Now, as far as ad hoc arbitration is concerned, the rules are generally set up by the parties, and in most cases, the arbitrators at the time of passing their procedural orders lay down in what form, what procedure the arbitration will be carried forward. The number of days a party would get to file their reply, the stage of evidence, expert evidence, the hearing dates, everything is fixed by the arbitrators. The procedure generally is streamlined by the arbitrators themselves. Whereas in cases of an institutionalized arbitration, the rules, the procedural rules are generally set off by the institution concerned. You may have heard the SIAC, ICC arbitration, or the MCI. All of these institutions have their own set rules for, be it for appointment of arbitrators, emergency arbitrators, which parties can refer to. But a word of caution, these institutionalized arbitrations generally tend to be a lot more expensive than your ad hoc arbitrations. So it is recommended that parties opt for institutionalized arbitrations where the stakes are high, huge sum of money is involved, and the dispute is more complicated or big companies are involved, multinational companies are involved.